Okay, good morning, everybody, and you are all very welcome to our latest webinar. Today's topic, gross negligence manslaughter, what your business needs to know, aims to answer all your questions and look at the potential impact it could have on your organization. So the new UK guidelines relating to GNM, gross negligence manslaughter, came into effect from the 1st of November, bringing the issue into sharp focus for employers. Should the worst happen, businesses need to be prepared. So today we have a panel of guests, experts in their area, who will discuss this topic, and we will just have a look at who we have with us today. So firstly, we have Bridget Leathley, chartered member of IOSH and owner of The Safer Choice. Bridget is a freelance health and safety consultant, providing risk management support in numerous environments. She delivers safety training and writes for numerous publications. And we also have Nick McMahon, Head of Health and Safety in Reynolds Porter Chamberlain. Nick specialises in health and safety and environmental regulation and regularly advises clients facing scrutiny from enforcement agents such as HSE, local authorities and environmental agencies. And myself, Billy O'Brien, co-founder and director of customer success within Effective Software, also a chartered member of IOSH, and have been working in the health and safety area for a good many years. And without further delay, I suppose just some maybe housekeeping rules and how we're going to operate the webinar today. So every attendee is muted, but please feel free to type in questions. We will be taking the questions at the end of the session, so we certainly will leave plenty of time for that. So please feel free to type in your questions as we go. We will collate them and take them at the very end. So now we'll just move into our topic, and I'll introduce Bridget.
Hello, good morning. Hopefully you can hear me better than some of you I think were able to hear Billy. Apologies for that. So gross negligence manslaughter, probably many of you will remember that back in February 2016 there were some new guidelines from the Sentencing Council for health and safety offences, which increased sentences quite significantly for health and safety offences. And in general, those tended to be fines on companies that went from being thousands and tens of thousands to being hundreds of thousands and into the millions. So this is a new guideline. This is not specific to health and safety offences. It covers other forms of manslaughter. So unlawful act manslaughter, loss of control and diminished responsibility. But as health and safety professionals, the manslaughter that we're most interested in is gross negligence manslaughter, which is this second one here. It's important to say as well, though, that gross negligence manslaughter it doesn't apply just to health and safety offences. It also applies to, in some cases, things like dangerous driving or parents who haven't looked after children or teachers that haven't looked after their children as well. So it includes other things as well. But Nick will tell us a little bit more detail about what manslaughter includes. But what we'll have a look at to start with then is the way that the sentencing guidelines work. So if we can move on to the next slide. Okay, so if you're familiar with the health and safety sentencing guidelines, one of the things that it looks at there is the risk of harm. Because we're talking about gross negligence manslaughter, this means that someone has already died. So the harm category is already assumed to be the absolute highest. So we go straight in by looking at culpability. The definitions for culpability are fairly similar to those that are used in the health and safety sentencing guidelines, and that there are the four categories. So we go from the highest culpability category of very high down to the lowest culpability category, and a couple of them in between. So quite often when you get appeals with the health and safety guidelines, it's because people are saying, well, it wasn't very high, it was only high, or it wasn't high, it was medium, or it wasn't medium, it was lower. So that's where a lot of the appeals will tend to take place, is trying to decide how culpable an organisation is. In this case, it will be how culpable an individual is. And the factors there overlap a little bit with some of the factors that we'll look at later on with mitigation and aggravating factors. So once it's been determined what the category is, that then determines both the starting point and the range. So if we take the very lowest category, then you could have a prison sentence between 1 and 4 years, but the starting point is 2 years. Whereas if you have very high culpability, you can see you could get a sentence of up to 18 years, but the starting point for consideration would be 12. So what takes you up or down from that 12 years are the aggravating factors or the mitigating factors. So the mitigation factors could take you down to a 10, even if you were highly culpable, or up to 18 if they decided that there were the severe aggravating factors. So let's have a look at those in a little bit more detail. Billy, that's it. I think there's a slight time delay between pressing buttons and the slides appearing. So the sort of things that we have for the aggravating factors, I've drawn a little devil with horns really. What we're talking about there is where organisations have had previous warnings. Now that could be that they've had a previous conviction. That's clearly an aggravating factor if it's for a similar offence. But we're not sure yet. But it could also include if you've had a fee for intervention notice that by doing something you're causing harm, and you accept that fee for intervention, but then you don't do anything about it, and as a result of that somebody dies. That would be considered. That could well be considered an aggravating factor. The other things that are going to aggravate it is how you behave once the death has occurred. So there have in the past been examples of organisations creating risk assessments and backdating them. That clearly would be, if that was discovered, looked on very poorly. Similarly, destroying evidence. I think the aggravating factor that I think is going to be an interesting one to try and tease out is that if there is evidence that the gross negligence, as it's deemed to be by the court, was motivated by money, well then that will be regarded as an aggravating factor. I think that would be quite interesting to tease out, because of course with the so far as reasonably practicable principle, we are allowed in deciding on suitable controls in the workplace to consider cost, time and effort of a control. So quite where you draw the line between, well, I decided not to do that because I didn't think that the risk was sufficiently high to warrant that particular cost, and where the court decide that you were saving money by not putting controls in place. I think that's going to be an interesting decision that they're going to have to make. So on the positive side, mitigation factors are going to include sort of the opposite of it to some extent. So if you've got a previously good record of showing that you take the health and safety of your staff seriously, or the health and safety of those that you impact, whether that's customers, clients, service users, that's going to be quite a useful mitigation factor. If you have actually reported yourself, so that you admit to what you've done, you cooperate with the investigation, you take action fairly early on after the event, so maybe you put controls in place, that's also going to help. The other thing that affects, as with other offences, if you plead guilty early, then that can give you up to a third of your sentence off. One of the other interesting, again, mitigation factors just to highlight is the fact that if an employee, because this offence of gross negligence manslaughter doesn't just apply to the bosses, the managers, it can apply to an employee. So if an employee's actions or gross negligence has led to the death of a colleague or the death of a client, and that employee can show that, yes, they did the wrong thing, but the reason that they did the wrong thing was because the employer didn't provide them with the necessary training, the necessary equipment, support, expertise, and so on, then the sentence for the employee could be reduced, and that, of course, might shift the burden of proof onto the employer, to whoever should have provided the competence, the training, the equipment and the support. So that's going to be an interesting one again to see how that pans out. We're only sort of 9 days into the new sentencing guidelines, so there's not a lot to go on at the moment. The devil is in the detail, and determining how it's going to be applied is going to be quite complicated. So I'm sure that's something that Nick will be able to explain.
Okay, yeah, very good. And apologies to everybody, the Wi-Fi signal hasn't been great. So I suppose, Nick, just as Bridget identified there, how do prosecutors decide who will be charged with gross negligence manslaughter, GNM?
Thanks, Billy. And good morning, everybody. Yeah, to understand this, I think we need to go back a step and ask what this offence actually is. What does it mean? And the offence of gross negligence manslaughter is where an individual has been grossly in breach of a duty of care owed in negligence to the person killed, and that breach has been a substantial cause of that person's death. The key word here is grossly. Gross negligence manslaughter, of course. What does that actually mean? And the question really is one of fact rather than law. The law doesn't specify what's gross. It's a circular question, and the judges acknowledge that. But it was said in one case, summarised in this way. The court said it's where an act or omission is so bad in all the circumstances as to amount to a criminal act or omission. Ultimately, that is going to be a question for a jury. So in deciding who to charge, the CPS will be thinking of the evidence before them and how that is going to be presented to a jury, and whether a jury are going to conclude that what's been done or not done is so bad as to amount to a criminal act. So typically in a workplace setting, what the prosecutor will do is to look at all of the systems of work that are in place. They'll be examining risk assessments, method statements, training records, arrangements for supervision of staff. If there have been previous incidents, what have the responses been, or have there been responses at all? What are the industry guidelines for any particular activity, and have they been followed? So if any of those elements are lacking completely, or if they're there, they're woefully inadequate, and as a result that has led to a death, all of those sorts of factors might point to gross negligence manslaughter. As a recent example that some people may have read about in the press, a couple of fairground workers were sentenced in June this year, so before these guidelines came into effect. This was in relation to a bouncy castle which blew away in high winds, killing a 7-year-old girl who was on the ride at the time. And it's quite interesting here to pick up on some of the language of the judge in that case. He said that at the heart of the negligence here was a failure to have, as the judge put it, any sensible regard to the weather. So here, high winds have been predicted for days. One of the operators had a Met Office app which had been displaying a warning over those days. Both the operators knew that a bouncy castle couldn't be safely operated if winds were much over 20 miles per hour, and there was actually HSE guidance to that effect as well. And both of them tried to calculate the wind speed by effectively guesswork. And this is interesting when considering how the judge described this. He called that approach the most hopeless, amateurish, dangerous system imaginable. So the strength of those words, I think, is significant, because it gives you some idea of what it takes for conduct to be regarded as gross. And in that case, the jury agreed with that. Another factor in that case was that the poor system in place was putting multiple children's lives at risk, not just the life of the child who died. And I think that where there's a risk of multiple fatalities, that will be a factor that prosecutors will bear in mind when deciding whether to charge. To summarise, really, prosecutors will be carrying out a pretty widespread factual inquiry, not just of the specific accident circumstances, but they'll be looking at the broader background of the case and the health and safety setup generally. Just as a little coda of that case, both of the operators in June were sentenced to 3 years imprisonment. Reference was made to the guidelines, but the judge said at the time, I can't take those into account because they're not yet in force. But my sort of analysis of the remarks is that that case would probably fall within the high culpability bracket. And you remember from Bridget's slide that the start point there is 8 years, with a category range of 6 to 12 years. So 3 years is what the couple were each sentenced to under the guidelines. They would have been looking at 8 years.
Okay, very good. And so it's that covers off in terms of the prosecutors deciding who will be charged, and I suppose you've kind of covered some of the circumstances as well around either the individual or the organisation being charged. I suppose, is there any other examples or anything that's kind of seen that people should watch out for? You know, maybe a health and safety professional.
Yeah, I mean, this question, I mean, two parts really, and in relation to an organisation, the answer is quite simple. Gross negligence manslaughter doesn't exist for an organisation. That offence was abolished when the corporate manslaughter legislation was revised in 2007. So organisations, if they're being investigated for gross negligence, it will be under that legislation, which is dealt with by separate guidelines. So individuals can be charged with gross negligence manslaughter, and in the sort of circumstances that I described. So, you know, in essence, I guess, where basic safety protection isn't there at all, or it's perfunctory or just fundamentally inadequate. So, you know, as Bridget said, we could be looking at employees of companies, but I think more commonly we're looking at sole traders or, you know, fairly senior people. They are, to my mind, the more likely ones to face.
Yeah, I think with the bouncy castle example, Nick, as I understand it, the two fairground workers were effectively self-employed. It was their bouncy castle, and so therefore they set the rules. Had they been employees and had the owner been a separate person who had sent them out without any instructions, without any guidance as to how to determine whether it was safe to run during various weather, then I guess in that case it would have been the owner of the organisation who would have been charged with gross negligence manslaughter rather than the employees. So in this case, although they're described as workers, which is a slightly ambiguous term, I think it is because they were entirely responsible for everything.
Yeah, I think that's right. You know, it was their undertaking, it was their activity. You know, they were part of a showground family, and the setup of the business perhaps wasn't a typical sort of workplace setting, but you're right. You know, had they been working under the auspices of somebody else, then that more senior person potentially could have been singled out for investigation, either for manslaughter or possibly for other health and safety charges. In addition, both those defendants, incidentally, they did face health and safety charges as well as GNM, and they were convicted of those.
Okay. Yeah. So I suppose that kind of leads the next question, and when is a suspended sentence appropriate? So I suppose it's back to the mitigation that Bridget had mentioned previously as well.
Yeah. Well, if there's a gross negligence manslaughter conviction, a custodial sentence is always going to be appropriate. You know, as Bridget's described, they'll range from the minimum of a year to a maximum under the guideline of 18 years. In certain circumstances, the court does have a discretion, it has a power to suspend a prison sentence. So what that means is that the sentence doesn't begin immediately. It will be, its commencement will be suspended for a period of up to 2 years. And what that means is that if an offence is carried out during that 2-year period, then that will trigger the custodial sentence. You know, the defendant at that point will go to prison for whatever length of time has been awarded. So sentences can be suspended, for example, where there is very strong personal mitigation. So if the defendant is otherwise of excellent character and you know, references to that effect can be obtained, that's something which might persuade the court towards suspending the sentence. Or something that you know, I see fairly often, where an immediate custodial sentence would have a significant harmful impact on others. So I had a case not that long ago where the defendant was it wasn't a manslaughter case, but the defendant was a sole trader with numerous employees, but this person actually was the business, and to send that person to prison would effectively have closed down the business and penalised all those employees who would have lost their jobs as the business ended. So in that case, a combination of very strong personal mitigation, character references, and the impact meant that although a custodial sentence was passed, it was suspended. There is, however, one very big caveat to all of that, and that's that the court can only suspend a sentence of of less than 2 years. So anything above 2 years, the sentence will be immediate. So the Bouncy Castle people, they did ask for a suspended sentence, but it wasn't possible. And in the majority of gross negligence manslaughter cases, it's unlikely that a sentence will be capable of suspension, because the prison sentences are by and large above 2 years, unless you're in the low culpability category.
Yeah, which is again one of those sort of paradoxes to me, Nick, in the way that it's all phrased, because if you fall into the lower category of culpability, could you really be considered to have been grossly negligent? Because the examples that you've given clearly are where there's a sort of almost black and white sort of decision that, well, that clearly then there were things that you knew you could have done and you didn't do. But if someone falls into that lowest category, I'm just not sure they'd even fall into being described as grossly negligent. So I think there's a sort of an issue with that lower category. It would be interesting to see if anyone actually falls into that without falling out of the system altogether into some other offence.
Yes, I think that's absolutely right. You may find in those sorts of cases that there will be a possibility for plea bargaining with sentences at the sort of range we can see in the low category. Health and safety offences can provide the same sort of punishment, and they're, as offences, a lot easier to prove than gross negligence manslaughter.
Yes. Yeah.
Okay, very interesting. And even interesting that, on the lower end of the scale, that the sentencing can be up to 4 years. So again, you're outside that window of 2 years that you mentioned as well.
Yeah, I think it just really reflects the gravity of this offence. Gross negligence manslaughter is right up there as one of the worst. So to talk in terms of low culpability, I agree, Bridget. It's
yeah. The definition in the guidelines is the negligent conduct was a lapse in the offender's otherwise satisfactory standard of care.
Yeah.
So if it's just a single lapse, I just don't know how anyone would call that gross negligence. So I think I have a feeling that's going to be an unused category.
Well, probably, yes, possibly a category to help cases end up in the medium culpability range. I can't see any prosecutor looking to put a case in the lower culpability range. So
it's just there as a baseline to move people up by the sound of it, then.
Well, we'll see, but that's quite possible.
Yeah.
Yeah. Okay. So I suppose that kind of leads us on nicely to, I suppose, what qualifies as reckless. So certainly in this slide, I think that qualifies. But it would be good to get maybe some examples that you've come across, Nick or Bridget.
Yeah, I think there's some room for confusion here. I mean, reckless doesn't actually form part of the offence. I mean, the courts have said that it's open to a trial judge to use the word reckless if that appears appropriate in the circumstances of any particular case, but the judge isn't going to be required to use the word or to give a detailed explanation to juries of what the word reckless means. So what the court and the jury will be looking at is how bad any particular negligence is, whether you call it reckless or not. I think the other point about the word reckless is that perhaps that might connote activity rather than inactivity, and of course gross negligence manslaughter can cover off omissions as well as negligent acts. So I think there's no particular magic in the word reckless, but I mean, just a couple of other examples aside from the Bouncy Castle case. One of them involved a demolition job. A builder sent a couple of brothers who were aged 15 to demolish a high boundary wall which had a large crack in it. Those two weren't given any supervision or any PPE or appropriate tools for the job. One of them came back and told the defendant that the wall was falling down, but he didn't go and see it. The wall collapsed and one of the brothers died. So that I think gives you a flavour of the sort of situation that would fall within gross negligence manslaughter. That defendant was convicted and he was sentenced to 3 years. I think, looking at the facts of that case, it would probably now fall within, I would say, the very high culpability category, and the starting point there is 12 years. So I think that's quite a good example of the difference the guidelines are likely to make. And they're just a slightly different sort of case. It was another builder that it concerned a carbon monoxide poisoning. The builder was working on a chimney and blocked the flue, despite knowing that that would create an obvious risk of carbon monoxide poisoning. The court regarded that as a blatant disregard of a very high risk of death. So, you know, whether one calls that reckless or not, it was deemed to be gross negligence. In that case, the defendant was sentenced to 2.5 years. Under the new guidelines, given the facts of that case, the start point would probably be 8. So another example of the difference. But you know, really, I think just to summarise, it's more than just mere negligence that the courts will be looking at. It's something that's gravely lacking.
Yeah. Okay. No, that's interesting and beneficial for people to understand that. I suppose you know, this again leads on then to what actions can you take, I suppose, to offence to charge.
Yeah, I know Bridget will have a view on this as well, but you know, I would say that as in most health and safety scenarios, prevention is better than cure. So, you know, having in place and following an adequate, safe system of work is going to be an essential basic, obviously, to stop an accident happening at all. That is the best way of avoiding a gross negligence manslaughter charge. But in the event that a death were to occur, I think the other line of investigation that I would take if I were asked to advise would be to look at the systems in place and try and persuade the investigators that if they're looking at any sort of offence, it should be a health and safety offence rather than gross negligence manslaughter. And the reason for that in relation to an individual would be that prison sentences are limited to 2 years, so if there were going to be prosecution, there would be a better prospect of keeping those individuals out of prison, which would be their job.
Yeah, I think I definitely agree with the prevention, and I say it's not rocket science. It's what health and safety practitioners, you know, should be doing. Most of them already are doing in reputable companies already. I'm sure, you know, anyone who's tuned in today is already doing this. And it starts with understanding what your operations are, identifying the hazards in those operations, making sure that you have risk assessments in place, that those risk assessments are suitable and sufficient, which means that you review them every time anything changes, you check, you update them, you make sure that the controls are in place. Those controls might include things like training and competence of the staff, making sure that systems have been audited, that your equipment is inspected when you say it is. And you know, again, I think the biggest thing that I see in most organisations is where they do have all the paperwork in place, they don't actually have any system for checking that all of that is being carried out. So, you know, if you were a bouncy castle operator and you had staff out on site, even if you've put them on a course and you've told them what to do, you need to be able to show that, you know, periodically you went and checked what they were doing, that you talked to them, you had some way of verifying that they understood what they needed to do, that when they came back to you and said, oh, I had to cancel that event yesterday, you didn't dock their wages and say, oh, well, next time, you know, you just better just carry on anyway. You have to actually follow that message through. If you've got risk assessments in place that say, we don't do this in these circumstances, or yes, you can stop the production line, or yes, you can stop. You can close the whole construction site down if you think it's not safe. You actually follow that through. So it does start with identifying the hazards and then just following that standard risk assessment process through and having the safe methods of work in place and making sure they're being followed.
Yeah, absolutely. And so just a quick reminder there for everybody. There's a good few questions coming in. So those coming, that'd be great. I suppose we are getting close to the end of the webinar, but keep the questions coming and we will follow up afterwards. So I suppose then, just in relation to this, guys, is there anything else that you guys want to add before we maybe jump into some of the questions from the audience?
No, I think just to say there will be, or there is already a blog on the Effective website that's worth looking at. There's also an article that I did on this for IOSH magazine. So if you want a little bit more detail, there's some examples in there, just to give you a little bit more colour to the sort of things that people get prosecuted for gross negligence manslaughter for.
Okay.
I think the examples sometimes kind of give it a little bit more of a colour and give a bit more of an understanding, because the saying, oh, it has to be gross negligent and it has to be clear and the rest of it, it's not obvious when you're talking in isolation. When you actually start looking at the examples, you can see just how bad some organisations really are, and that, you know, for any reputable organisation that's trying to do their best, it's very unlikely that they would end up with this as a sentence. There would have to be something going badly wrong within the organisation. Unlike the health and safety offences, where I think it's much easier to fall into one of the categories, I think with the gross negligence manslaughter, you have to be,
Absolutely,
you have to be almost deliberately careless.
And I think the relatively low number of convictions for that offence is testament to that. I think we've had 10 over the last year or so. That's a pretty low number.
Yeah.
So, you know, I think in the majority of fatality cases, whilst, you know, gross negligence manslaughter would always be looked at the start, the stats suggest that the health and safety legislation is going to be where the majority of these sorts of incidents end up.
Yeah. I mean, I think an interesting case with that, where gross negligence manslaughter was considered, but then it wasn't pursued, was the SAS supervisors, so the 3 Army reservists who died of heat stroke back in 2013. And when from the facts as they were presented on the news was, you know, these dreadful SAS supervisors had made these poor men, you know, run with kit on the hottest day of the year, and, you know, 3 of them had died as a result of dehydration. And that sounds sort of inhuman, and you would think, well, yes, that is grossly negligent, surely. But of course, when you look at the facts of the case, actually the SAS supervisors were following Army protocol absolutely to the letter.
Yeah.
And so in the end, it was sort of it was clear that the gross negligence manslaughter wouldn't apply, because they were doing, you know, they were obeying orders. They were doing what they were told to do. So it can superficially look like there's a gross negligence manslaughter case, but actually the facts of the case might show differently. I mean, I guess the interesting one to follow next year, I think the police commander at Hillsborough, I think it's gross negligence manslaughter he's being charged with, Nick, is that correct?
That's right, yeah, David Duckenfield. I mean, it's obviously an extremely unusual case and particularly tragic one, but I think from a legal perspective, it is going to be interesting to see how that
yes, and I think particularly because that wasn't like some of the other cases where, I mean, presumably the Bouncy Castle people had been breaking the rules on the weather for some time. The guy getting the 15-year-olds to build a wall, presumably that was his practice, was to use underage workers and untrained workers and to not supervise the work.
Yes.
The Hillsborough case seems to be a one-off decision on one day, so that's why it will be interesting to see whether that does end up.
And as I understand it, a decision by an individual who was, you know, pretty new to that post. I mean, obviously we'll have to await the detail of that case as it comes along. But yes.
Determining the facts 30 years later in any case seems to me.
Yes, pretty difficult. Although I think it's fair to say there has been an exhaustive investigation of those facts over the years. So we shall see. But I mean, if there is a conviction, even though the offence was, if an offence it was 30 years ago, the current guidelines would be the guidelines that would have.
Yes.
So it would be interesting to see how the judge would deal with that.
Yeah, absolutely. So it's interesting. Just a good few comments coming in, reinforcing your opinion in terms of the prevention is better than the cure. So making sure your house is in order and you have all your training, risk assessments, and so on in place. So I think a big thumbs up on that. Everybody is in agreement there. So just to jump in maybe to the first question. So we have one question here. I'll throw this out to both of you guys. I understand aggravating factors is that others are blamed by the offender. If you think someone else is responsible, how do you handle that?
Yes, so I think in the case of, I mean, let's just take a hypothetical case where an employee made a mistake on the day that led to someone's death. If that employee then tried to blame another employee, and it turned out it wasn't the other employee's fault, I think that would be considered as an aggravating factor. I mean, more commonly it tends to be where the employer has been responsible for something, but says, oh well, I did tell all the workers that they should do this, or I told them they shouldn't do that. I told them hundreds of times not to do that, and then they can't actually prove that they did follow that through, or that actually that was what they were really doing, but they were trying to shift the blame onto the employees. I think that's particularly where the courts would come down hard on someone, because clearly they're not cooperating. They're trying to shift the blame. They're lying. They're maybe fabricating evidence in order to shift the blame onto someone. So, for example, if I created a training record to say, yes, look, I did train them in how to operate that piece of equipment, it's not my fault that they decided not to follow my training protocol, and that would definitely be a case of shifting blame.
Yeah, and obviously you have to make sure you prove that you have trained them, you have all the records and everything, and can easily back that up.
Yes, and I think the thing is, it's all very well proving that you've trained people, and that's great. So if you've got an e-learning system that says, yes, I can demonstrate that these people did this e-learning course and they passed they answered these questions at the end, that's the first part of it. That's great, but you need to follow that up by saying, and then their supervisor checked their competence on the job, or we have some other way of checking their competence on the job, because passing an e-learning test, I mean, they're very valuable in their own place, but on its own, that wouldn't be sufficient to prove that you knew that they were being competent on the job itself.
Yeah, exactly, down to supervision. Here's another one actually that maybe for you, Nick. So, is any weight given to the actions of the person who has been, I suppose, killed as a result of an incident as a defence?
In the context of a prosecution, no. I mean, when I'm looking at civil claims for damages, contributory negligence plays a part, but no, that isn't something which will impact on gross negligence manslaughter charge. You're looking at the acts or omissions of the defendant.
I think examples of that are things like where children trespass onto building sites or onto railway lines, and the fact that the children were trespassing is irrelevant, I think, to the facts of the case.
Yes, to the offence. Yeah, that's right.
Okay, very good. And another question here: why is it a persona opposed to a company is culpable under GNM?
Yes, GNM is an offence that can only be committed by human beings, not by corporate defendants. And corporate defendants will face or would face a charge of corporate manslaughter under separate legislation, and the test for establishing that offence is different. It's looking at the actions of management, so it is looking at the behaviour of human beings, but it would be the company, the artificial person, that would be the defendant in that sort of charge.
Okay, right. Here's an interesting one then. Is there real potential for GNM to be used on incidents that occurred prior to the 1st of November?
Yes, is the short answer. The offence itself hasn't changed. It's only the sentencing guidelines which have, and it's clear that they apply to offences whenever they occurred. So, as I said, the police officer in relation to Hillsborough, that's obviously a very dated event, but if there were a conviction there, then these guidelines would apply, but the offence itself is as it was 30 years ago.
Okay, very good. There are a load more questions here to go through. I think we're out of time now. We've just gone over the 40 minutes, and I know it's Friday and everybody has work to do and try and finish up early and enjoy the weekend. So I'd like to thank both panelists, Bridget and Nick. I found it very insightful, and I hope our audience have as well. Keep the questions coming. We will be putting this on our website, and we'll get back to every respondent as quickly as we can as well with answers to the questions. So again, thank you very much, guys, and it's been a pleasure.
Thank you very much. Likewise.
Yeah. Thank you.
Goodbye.